In May 2026, an AI law firm produced court documents that were scrutinized by opposing lawyers and a judge in a contested trial. Nobody commented on the AI drafting. The barrister who presented the case said the documents were more than sufficient for the purposes of this trial. That result didn't happen by accident. It happened because the workflow around the AI was right. This episode covers how to build that workflow for your own litigation practice using Claude. The complete setup: matter project, intake prompts, document triage, witness preparation, motion stress testing, settlement read, and the verification habit that keeps everything court ready. Everything from this episode is in the free Litigation Claude setup guide. The link is in the description. Download it before you start and use it alongside the episode. Before you do anything else on a new disputed matter, set up the Claude project. A litigation matter project is a permanent home for everything Claude needs to know about the dispute. Set it up at the point of instruction, and every conversation on that matter starts already calibrated. Claude already knows who the parties are, whose side you're on, and what the dispute is about. Here's the project instructions template. I am a solicitor or barrister acting for client name in matter name. My client is the claimant or defendant. The dispute concerns one sentence description. Jurisdiction, jurisdiction. Court, court if known. I want output in plain, direct legal English. Flag anything uncertain with verify. Do not invent facts, dates, names, or case references that are not in the documents I provide. That's the template. Fill in the 5 fields. Paste it in. The project is set. What goes in the project knowledge? The pleadings as filed, the key correspondence, any orders already made, and the chronology if one exists. Don't load everything. Load what Claude needs to have permanent context on the matter. The documents you need in every conversation go in the project. The documents specific to one session get uploaded in that conversation. 3 intake prompts. Run these at the point of instruction, or when you first pick up a matter you haven't seen before. Intake 1. The cold matter brief. Read these documents. Brief me as if I'm a senior lawyer who knows nothing about this matter. Give me the dispute in 2 sentences, the parties, the key legal issues, the current position, what's open, and the 3 things I need to know before I speak to the client. That prompt gives you full matter orientation in 60 seconds. Intake 2. The chronology framework. Extract every event in this matter in chronological order. For each event, the date, what happened, who was involved, and which document records it. Flag any gaps in the timeline where an event should be recorded but isn't. The gap flag is the most valuable part. In litigation, what's missing from the chronology is often more important than what's there. Intake 3. The party and issue map. Identify every party in this dispute, their role, their interests, and their position on each key issue. Then list every legal issue in dispute and what evidence exists on each side for each issue. That prompt produces the map you need for every strategic decision that follows. Run all 3 before the client call. Every time. Document triage in litigation is the same 4-pass review from the document work episode, but the stakes are different. In a disputed matter, what's missing from the disclosure is often as important as what's there. 4 passes on every litigation document. Pass 1. What's in it? Summarize this document. What does it record? Who produced it? And what does it establish about the factual position? Pass 2. What's unusual? What is unusual, inconsistent, or unexpected in this document compared to what you'd expect in a matter of this type? Pass 3. What's ambiguous? What language in this document is ambiguous or capable of being read in more than one way? Which reading benefits each side? Pass 4. What's missing? What should be in this document or the wider disclosure that isn't? What documents should exist that haven't been produced? Run Pass 4 on every disclosure set. Not just the documents, the set. Claude will identify what should have been disclosed and wasn't. That's where the case is sometimes won. Witness preparation. Here's where the line is, and here's what Claude can help with on the right side of it. What Claude can do? Organize the documents relevant to each witness. Identify inconsistencies between what a witness has said and what the documents show, and develop the questions for a witness conference based on the issues in dispute. What Claude cannot do, and what you should never use it for? Telling a witness what to say, coaching evidence, or suggesting answers to anticipated questions. Any instruction that could constitute witness coaching under your jurisdiction's professional conduct rules stays off the table. That's not a preference. That's professional conduct. The witness conference prep prompt. Based on the documents in this matter, what are the 10 most important questions I need to ask witness name in our witness conference? Focus on areas where the documents create issues I need to explore with them. Claude identifies the questions based on what the documents show. The witness answers them from their own recollection. That's the right side of the line. Before any submission goes to court, run the stress test. 4 reads. Every time. Stress test 1. The opposition read. Read this submission as counsel for the opposing party. What are the 3 weakest points in my argument? What would you attack first? What authorities would you rely on to counter my position? This is the read that finds the weaknesses before opposing counsel does. Fix them first. Stress test 2. The judicial read. Read this submission as a judge, seeing it for the first time. What questions would you have? What is unclear? What would you want addressed that isn't? What would make you decide against this party? The judicial read catches structure and clarity issues the opposition read misses. Stress test 3. The authority check. List every case and statutory provision cited in this submission. For each one, confirm whether the proposition for which it is cited accurately reflects the authority. Flag any that should be verified. This is the starting point for citation verification, not a replacement for checking on Westlaw or LexisNexis, but the prompt that tells you what to check and where to focus. Stress test 4. The factual accuracy read. Compare the factual assertions in this submission against the documents I have provided. Flag any assertion that is not supported by a document in the record, or where the document says something different from what is asserted. 4 reads. Before it goes anywhere near the court file. Before any settlement discussion, read the file. Not your notes, the file. Claude can read the full matter and tell you where the pressure is on the other side, the gaps in their evidence, the weaknesses in their position, and what the commercial reality looks like from where they're sitting. 3 settlement read prompts. Settlement position read. Based on the documents in this matter, what is the other side's likely settlement position? What are the weaknesses in their case that might motivate them to settle? What are the risks to my client if the matter proceeds to trial? Quantum read. Based on the documents, what is the range of outcomes at trial for my client? What is the best case, the likely case, and the worst case? What factors would push the outcome in each direction? Risk read. What are the 3 biggest risks to my client's position in this matter? What evidence would most damage their case? What has the other side that we haven't fully addressed? Claude won't make the decision. You will. But these 3 prompts run before the conversation, not during it, mean you walk into any settlement discussion knowing what the file says about where each side actually stands. The Garfield documents passed because the workflow around them was right. The Pinsent Masons and Sullivan and Cromwell situations happened because the verification step was skipped. 3 verification steps. Every document that goes out under your name. First, verify every case citation through a proper research tool. Not a Google search, not asking Claude to check itself. Westlaw, LexisNexis, or Fastcase. Every case name, every proposition, and the supporting citations get checked as carefully as the lead authority. Second, run the factual accuracy read before filing. Every factual assertion in a court document gets checked against the documents in the record. If it isn't in a document, it doesn't go in as a fact. Third, Clear every verify flag before the document leaves. Every flag Claude has placed is a task, not a suggestion. None of them go out unresolved. This is the habit. A complete verification system for litigation practice. The 5-point protocol, the supervision framework for junior use, is coming to this channel as a dedicated product. This is the habit that sits underneath it. The Litigation Project. 3 intake prompts. Document triage, 4 passes. Witness preparation, on the right side of the line. Motion stress test, 4 reads. Settlement read, 3 prompts before the conversation. And the verification habit that keeps everything court-ready. That's the complete Claude setup for litigation practice. The free Litigation Claude setup guide has every prompt from this episode, the project instructions template, and the verification checklist, all in one document. Download it from the link in the description, fill in 5 fields, and your first litigation project is ready. That's the episode. See you in the next one.